Dealing firstly with you, John O'Malley. You're 43 years of age now, and you were present from an early stage at the disturbance on St Luke's Road in Southport. There is very clear footage showing the developing disorder, and you were at the front of what was essentially a baying mob. You were part of a surge that broke through police lines, and you were standing next to the police vehicle that was being destroyed. You were present while missiles of every description were raining down on the officers, including bricks, traffic cones, wheelie bins, road signs, tins of paint, and the occasional firework. It was relentless, and you were at the front and participating enthusiastically. I have seen the footage, and there were plenty of opportunities for anyone to leave who did not want to be there. You were arrested 5 days later and made no comment in interview. You have 2 previous convictions, including a recent one for assault by beating. You have, of course, pleaded guilty, and you are entitled to full credit for that plea. I'm told that you now deeply regret what you did on that night. But apart from that, there is very little further mitigation available to you. Turning to the sentencing guidelines, I am satisfied that your offending falls into culpability category B, because you participated willingly in an incident involving widespread and large-scale acts of violence on both people and property, where there had obviously been planning by someone, and it lasted for several hours. In terms of the harm caused, it is Category 1, because almost every Category 2 factor is present, and they have to do with the significant resulting injury and fear and distress. Dealing next with you, William Nelson Morgan, you are 69 years of age now, but your advancing years plainly did not prevent you from playing an active part at the disturbance on County Road. You were a part of a crowd of about 100 people who were running amok, setting fire to bins and damaging local property, including a community hub and library which contained a food bank and provided an important resource for the people living in that area, that library and hub based at Spellow Lane. The crowd threw bricks that night and bottles, and bins were set on fire, and they too were hurled at the defending police officers. As those officers were trying to regain control, you were seen at the front of the mob, holding in your hand a wooden cosh, a small truncheon, which you plainly had with you to use as a weapon. When officers tried to arrest you, you resisted with such force that it took 3 of them to detain you. And later, when asked about the cosh, you said, remarkably, that you had taken it with you that night for your own protection. The sentences that I am about to impose have been reduced by 1/3 to reflect your pleas of guilty, and you will both serve up to 1/2 of those sentences in custody before you are released on licence. If you fail to abide by the conditions of your licences, you can be returned to serve some or all of the remainder of those sentences. Will you both now stand up? In your case, John O'Malley, for the offence of violent disorder, the sentence is 32 months imprisonment. In your case, William Nelson Morgan, for the offence of violent disorder, the sentence is also 32 months imprisonment. That sentence intended to reflect that offence and the associated offence of possessing an offensive weapon. For the associated offence, there will be a concurrent sentence of 6 months imprisonment, reflecting, as I have, the principle of totality. The total sentence is, therefore, one of 32 months imprisonment in your case. Because of your possession of the weapon, I am also satisfied that it is necessary to make a serious violence reduction order to protect the public from future harm. It will last for a period of 2 years and will not take effect until you are released from custody. Those are the sentences of this court. You may now both go with the officers.